On the evening of October 13, 2023, a serious traffic collision occurred in San Antonio, Texas, when Simon Alexander Garza allegedly drove at an excessive speed, ran a red light, and crashed into a Honda driven by 50-year-old Jose Fernandez. Sergeant Richard Morales of the San Antonio Police Department responded to the scene. At the time of the crash, Mr. Garza was issued only a traffic citation for driving without insurance, and no criminal charges were immediately filed. The investigation took a different direction after Mr. Fernandez later died from blunt force head injuries sustained in the collision. On November 10, 2023, investigators recovered data from the vehicle's event data recorder, which allegedly showed that Mr. Garza had been traveling at a significantly excessive speed before the impact. Based on the event data, together with the victim's death, authorities concluded that probable cause existed to arrest Mr. Garza on a felony manslaughter charge. The defense, however, argued that the prosecution overlooked important medical and toxicological evidence. According to the defense, forensic testing indicated that Mr. Fernandez had alcohol, marijuana, and cocaine in his system at the time of the collision. Investigators also recovered an open container from the center console of his vehicle. Additionally, the defense—
I'm sorry, one other thing on the crash report. You don't have any toxicology results on the deceased, correct?
If I had them, yes, and I request them, yes.
Okay, but we had toxicology in the medical records for Jose Fernandez, and you didn't update that on this crash report, correct?
They were not given to me, and I did not request for them or put a subpoena in for them.
Okay. What about an open container? Is that important to a crash?
It can be for if the officer observed it, they can put it, give the person a ticket.
Okay, but no one was given a ticket for having an open container in this incident.
I do not believe so.
But you're aware there was an open container in Jose Fernandez's vehicle, correct?
Again, I can't, like I said, that's the officer who wrote that. A container can also be bursted open by a crash.
Okay, that wasn't my question. You're aware there was an open container in Jose Fernandez's vehicle, correct?
I can't exactly say if it was open or not, because like I said, the video I see a container there, and again, I don't know if it was opened or crushed open by the crash.
And you actually went to the scene.
That's correct.
And you saw Jose Fernandez's vehicle.
Yes, I saw the Honda. I observed a can in the vehicle. I did not pay attention if it was open or closed.
Don't you think that that's important to a crash investigation and whether someone is driving with an open container?
That's for the officer. If they observe it, it has to be observed by the officer.
Okay, can you listen to my question? Okay, don't you think it's important to note whether there was an open container in a vehicle when there's a crash?
Again,
Yes
you have
or
to
no?
have,
Yes or no?
it can be.
Okay. Why would it not be important that someone is driving with an open container when they've been involved in a motor vehicle accident?
So whenever we're at the scene, somebody says, hey, the person smells like intoxicants, strong odor, go to the hospital. They say they have a strong odor, and that's significant.
Okay, and so driving with an open container, as long as you don't smell like alcohol, you're okay? It's not important?
Now, I think the traffic code says that if it's officer observed it, you give them a ticket.
Right. It's against the law to drive with an open container, correct?
Okay, yes.
Okay. And drinking while driving impairs someone's driving, does it not?
It can, yes.
Okay. What about smoking marijuana before driving? That will impair your driving.
It could, yes.
What about doing cocaine prior to driving? That will affect your driving.
Yes, it could.
What about the combination of all three substances? That will affect someone's driving.
It could.
But that wasn't important to your investigation.
I didn't have any of those information with me.
But you had the open container. You saw it.
I can confirm that the driver was the one who consuming of any of that alcohol.
Sure. However, have you ever seen an open container in a center console and given the driver a ticket, even though there were other people in the vehicle?
That's correct. So I observed it. I can give that person a ticket. Again, the officer will have discretion to be able to give a ticket.
Okay. But you didn't observe the driver drinking. You just saw it in the center console and assumed it was theirs, correct?
I didn't observe that. Like I said, I observed the can. I didn't observe it was open to the point where somebody is maybe opening it to drink it.
Right. I'm talking about in the past. You said you have seen an open container in someone's center console and given the driver a ticket for an open container, even though there were other people in the vehicle, correct?
I'd have to go back and check my records. I don't actually think I've ever given that kind of ticket.
Okay,
Again, yes, that is the law. That is a state law.
okay. And so wouldn't you agree with me that it's due diligence for you to check a beer can to see if it's cold to the touch, if it's in the vehicle and someone was just in an automobile accident?
Again, I observed the can in there. That's all I had to do is be able to observe the can. It's on video and pictures.
Okay, let me ask my question again. Wouldn't you agree with me that it's due diligence for you to see if a can of beer in someone's vehicle after an automobile accident is cold to the touch?
Yes.
Okay, did you do that?
No,
And to your knowledge, did any officer at the scene do that?
I do not know that.
Did you question any of the occupants of Jose Fernandez's vehicle about the open container that was in their car?
I did not.
In your investigation, did you learn of any officer questioning anyone in the vehicle about an open container?
I did not.
Did you also have, is it your decision on what citations are issued?
It is not.
It is not. Okay. Are you aware that Simon was only issued a ticket for no insurance?
That was on the officer report, but I don't tell them to write that ticket.
Okay.
Asserted that Mr. Fernandez was suffering from stage 4 kidney cancer that had spread to his brain, arguing that his underlying medical condition should also be considered when evaluating the cause of death. The case proceeded to trial in the 187th District Court of Bexar County, Texas, before Judge Stephanie Boyd, with jury proceedings beginning on April 12, 2026. After the prosecution concluded its direct examination of Sergeant Richard Morales, defense attorney Marissa Jovenko began a detailed cross-examination aimed at testing the strength of the state's investigation. One of her first areas of focus was the open container discovered inside Mr. Fernandez's vehicle. When questioned about its significance, Sergeant Morales acknowledged that he did not consider it relevant during his investigation. The defense highlighted Section 49:031b of the Texas Penal Code, which makes it an offense to knowingly possess an open container of alcohol in the passenger area of a motor vehicle.
But probable cause. So if you have probable cause now for a manslaughter after Mr. Fernandez is passed, why wouldn't you have had probable cause for an aggravated assault at the scene?
The elements aren't there.
Okay, but the only difference is someone passed away, correct?
No, it's the speed of the vehicle and the disregarding the red light.
Okay. And you didn't know either of those factors at the scene of the crash?
That is correct.
Okay. And it took you a year and a half to find those, to learn that?
No, I think if I look at can I look at the date? Yeah. So the vehicle speed was observed on 11/10 of 2023, which is a month, a little under a month.
Okay. And so at that point, you went and got a warrant?
The warrant is before that to get the ACM.
No, I'm talking about for my client.
I did not get a warrant.
Okay. Did you present the case to the district attorney's office?
I did.
When did you do that?
I look at my notes. Submission date shows November 24th of 2023.
Okay, November 24th, 2023. And you said, what was the date you said you learned of the speed?
November 10th.
Okay. And so without speed, you wouldn't have had enough.
That is correct.
Okay. What's failure to maintain a proper lookout?
Proper lookout?
Mhm.
I'm not sure what you're referring to. Can you elaborate?
I mean, that's the question. What is there an offense for failing to maintain a proper lookout? Have you ever heard that before?
Like as if you're a lookout for a criminal act?
You know,
You're the lookout while somebody else is doing a criminal act?
It's a very good question. These are things the state is alleging. So have you ever heard of that? Is that an offense, a traffic offense that you've heard of? Failing to maintain a proper lookout?
You'd have to be more clear. Again, I don't really understand what you're asking.
Okay, there is not.
Taking one little piece out of there, but you have to explain what
Yeah.
what you're referring to.
Sure, there is not a traffic offense called failing to maintain a proper lookout, correct?
There's not a traffic offense. It's within a traffic offense.
Okay.
That's why I'm asking you to elaborate because
within-
it's within It's within the traffic offense. It's not a specific traffic law violation.
Okay, what traffic offense is it within?
Within basically for stopping at a yellow light, maintaining, observing traffic controls,
For stopping at a yellow light?
a red light.
At a red light. Okay, so speeding is what changed to you to give you probable cause for manslaughter, is what you're saying.
That is the element that I needed as well. Yes, correct.
Okay.
With the red light.
Okay. And so if every person who speeds on the road committing an attempted manslaughter?
Unless they cause the death of another person while committing another violation. It has multiple violations while committing a death of another.
You requested the manner and death of from the medical examiner, correct? The cause and manner of death?
That's correct.
Did you review that?
I don't have it with me up here, but yes, I did.
Okay. Agree with me. The cause of death was blunt force injury related to renal carcinoma, correct?
Again, unless I see it in front of me, and
Okay. Well, you can use your report to refresh your memory.
I need the autopsy report.
No, your report. You talk about it in your report. About second paragraph from the bottom, from the conclusion.
Yes.
Okay.
Vehicle located on a public highway, regardless of whether the vehicle is moving, stopped, or parked. Building on that point, the defense argued that Mr. Fernandez was allegedly committing a misdemeanor at the time of the collision. Attorney Jovenko then turned the jury's attention to Section 49(04) of the Texas Penal Code, which prohibits operating a motor vehicle in a public place while intoxicated. According to the defense, Mr. Fernandez's toxicology report indicated the presence of alcohol, marijuana, and cocaine in his system, evidence they argued supported a finding of statutory intoxication. By combining the toxicology evidence with the relevant provisions of Texas law, the defense sought to argue that the collision was an unavoidable accident rather than the result of criminal recklessness by Mr. Garza. Ms. Jovenko also questioned Sergeant Morales about whether the mere act of running a red light and causing a traffic collision was, by itself, sufficient to establish probable cause for a manslaughter charge. She pointed the court to Section 19(04) of the Texas Penal Code, which defines manslaughter as recklessly causing the death of another person. The defense further emphasized Section 6(03)(c), arguing that the prosecution must prove not only that a fatal collision occurred, but also that
Officer, I'm sorry, detective. The legal limit for your blood alcohol in driving is 0.08, correct?
That's correct.
Anything above a 0.08 would be an intoxicated driver.
Yes.
And that's only alcohol. Additional substances would definitely affect the level of intoxication.
Yes, we have to have the measurement of what it is, how much they have in the.
Okay. And officer, I'm sorry, detective, you went to the A's Up Sports Bar to collect the video that is still on the screen, correct, of the crash?
That is correct.
Okay. And you remember talking to the sweet old man who owns the bar?
The owner of the bar, that's correct.
Yes. Okay. You remember telling him that this is just an accident, it's nothing criminal?
I do not recall. Again, I can talk to them. A lot of people don't like to hear bad news, so I'm just basically creating a rapport.
So if you said that you were lying to him?
I'm just talking to him.
Okay. But do you remember telling him multiple times that this isn't anything criminal, it was just a crash?
Again, just building rapport with the person who's going to share video.
Okay, just a yes or no. Do you remember telling him, I want to say 3 or 4 times, that this is just an accident, it's not criminal?
Again, I didn't watch that in the video showing back there, so I'm guessing you saw it. I don't recall.
That's the answer. You don't remember saying that. Okay, so would reviewing that in your video help refresh your memory?
Sure.
Okay, officer, you watched your body cam now. Watched your portion of the body cam now.
Yes.
Okay. And you recall stating that this isn't anything criminal, it's just a crash.
Yes.
Viewing his
defendant
Bodycam
consciously
footage,
disregarded
Sergeant
a
Morales
substantial
confirmed that
and
while securing
unjustifiable
evidence at the
risk,
scene,
a
he
legal
explicitly
standard
told
that
Mr.
requires more
Garza
than
that the
ordinary
incident was
negligence or a
nothing
routine
criminal.
traffic
Under the Community
accident. The
Caretaking Doctrine and
cross-examination
Texas
intensified
Transportation
when
Code,
Sergeant
Section
Morales was confronted with the medical
550.022, a
examiner's
motor
official
vehicle
report
collision is
concerning
initially
the
treated
cause
as a
of
routine
Mr.
traffic
Fernandez's
accident
death.
centered
The
on
defense
emergency
next
response, public
focused on the
safety, and
medical
property damage
examiner's
assessment.
findings.
However, the legal
According to the
classification
official
shifts
autopsy
from a
report,
civil
Mr.
traffic matter to a
Fernandez's
criminal
death
investigation
resulted
the
from
moment law
blunt force
enforcement
trauma that was
suspects that a
compounded
driver
by
was
advanced
engaging in
renal
reckless driving.
carcinoma.
Because the
During
incident was initially
cross-examination,
framed to scene
Sergeant
witnesses as a
Morales
regular
acknowledged that
accident,
he
no
was
criminal
unaware of the
charges were
victim's
pursued
cancer
immediately.
diagnosis
Nevertheless,
while
the legal
conducting
scope
his
of the case
investigation
shifted
and
once
did not
officers
dispute
obtained
the
definitive
medical
knowledge of
examiner's
Mr. Garcia's
conclusions.
excessive
Attorney
speed.
Marissa
However, while an
Jovenko
indictment
then
has been
directed the
filed,
court's
the prosecution
attention to
retains
Texas
the
Penal
absolute
Code
burden of
Section
proof
6,
pursuant to Texas Penal Code,
04A,
Section
arguing that the
2.0,
case
statutory
presented a
element of
complex
this
issue
reckless
of
conduct
concurrent
beyond a
causation.
reasonable doubt
Under
at trial.
Texas
Very quick question, Judge. Detective, in regards to that statement, do you recall when it was made?
You talking about the video,
The
the
date.
statement I made? Yes. Saw it on top of our camera. I believe it's the 24th.
Okay,
I remember it was after the crash when I was going to get the video.
okay.
Hang on. No, there's no time up there.
Was it, how about this? When was it in relation to when you got the report of the speed back?
It was prior to that.
So it was before you decided to file charges?
Correct.
Pass a witness.
In fact, you also stated that you can't take someone to jail for running a red light, right?
I didn't say that.
You didn't say that?
No.
And if speed was a factor to the crash, don't you think that that's a pertinent detail that you should update on the crash report?
No, again, I'm not going to change the officer's crash report and the speed because it wasn't relevant at the time the crash report was written.
Okay, but you testified that you're supplementing the crash report to add all of the pertinent details.
Can I look at it? Is there a block for the
Well,
speed?
just listen to my question. You testified that you supplement the crash report to add all of the pertinent details. Was that not the exact words that you said?
Okay, yeah, there is not a speed block to enter onto the crash report.
Officer, I'm sorry. Please just answer my question. Okay, I'm asking you. You testified that you supplement the crash report to add all of the pertinent details, correct? Okay. Now, you're trying to tell the jury that there is not a portion for how fast the car was going. I understand that. Look at page 2. There is a spot that says contributing factors to the crash. Is there not?
Correct.
Okay. You did not supplement to add speed as a contributing factor to this crash.
Correct, because I put it on my.
I did not ask you why.
All right.
Thank you. And but you did testify that you would supplement to add all the pertinent details. And you can, there's no limit on how many times TxDOT will allow you to supplement a crash report, correct?
Correct.
Okay. You also did not supplement it to add any intoxication or narcotics usage to Mr. Fernandez.
Correct.
Pass the witness.
No further questions, Judge.
All right, is this witness excused or subject for recall?
He is excused by the state.
Subject to recall, Judge.
This law, criminal responsibility depends on whether the prohibited result would have occurred but for the defendant's conduct, while also considering whether another independent cause was sufficient to produce that result. The defense argued that Mr. Fernandez's advanced stage 4 kidney cancer, which had reportedly spread to his brain, constituted a significant pre-existing medical condition. According to Ms. Jovenko, that condition should be considered a concurrent cause of death, making it questionable whether Mr. Garza's actions alone were legally sufficient to establish criminal liability. The cross-examination then shifted to Sergeant Morales' body-worn camera footage. After reviewing the recording, the sergeant confirmed that while processing the crash scene, he told Mr. Garza that the incident was nothing criminal. The defense used that statement to argue that officers initially treated the collision as a routine traffic accident rather than evidence of a criminal offense. Under the Community Caretaking Doctrine and Texas Transportation Code Section 550.022, law enforcement officers responding to a traffic collision are primarily responsible for protecting public safety, assisting those involved, and documenting the crash. The defense argued that only after additional evidence emerged did the investigation evolve into a criminal case. Although the collision was initially handled as a routine traffic accident, the investigation took a dramatic turn once law enforcement began to suspect that reckless driving may have played a role. Because first responders and witnesses initially viewed the incident as a standard motor vehicle crash, no criminal charges were filed at the scene. That changed after investigators recovered evidence that allegedly showed Mr. Garza had been traveling at an excessive speed before the collision. Based on that evidence, prosecutors presented the case to a grand jury, resulting in an indictment.
The state of Michigan versus Sierra Ryan Robbins, 25-00116. Appearance, please.
Good afternoon, Your Honor. Abigail Wilson on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Ms. Robbins, who is standing to my right.
Today was the date scheduled for preliminary examination on carrying a concealed weapon. Are we ready to proceed?
The people are ready, Your Honor. Thank you.
Yes, sir.
Any preliminary matters before we call witnesses?
Not from the people.
Not from the people, sir.
Would you call your first witness?
Thank you, Your Honor. The people call Officer Burkett.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
You can have a seat. You can state your first and last name and spell both.
Elena Burkett, ELANABURKETT.
You can proceed.
Thank you, Your Honor. Officer Burkett, where are you currently employed?
City Lansing Police Department.
And what is your job title?
Police officer.
What are your general duties?
Respond to calls for service, self-initiated activity, and officer advising role.
How long have you been a police officer?
With Lansing, it'll be 2 years and 14 days. And overall, I think I've been licensed for about 3 years.
Okay. Now, were you working as a Lansing police officer on December 12th of 2024?
Yes.
And what was your assignment on that date?
Road patrol.
And were you in the area of South Pennsylvania Avenue and Alden Drive?
I got dispatched for a personal injury accident.
And what were you wearing while you were working that date?
Full uniform.
And does that have police on it?
It does.
And were you in a car, on foot, or something else?
I arrived in a fully marked patrol car.
And is that department issued?
Yes.
Now, on that December 12th date, you said you were dispatched for a personal injury accident, is that correct?
Yes.
And by that, do you mean a motor vehicle accident?
Yes.
Okay. Now, when you arrived at that location, what was happening?
There was a car in the northbound lanes of Penn, slightly in the road, that appeared to have collided with the curb and then a traffic closure.
And that location of South Penn and Alden Drive, is that in the city of Lansing?
Yes.
Ingham County?
Yes.
State of Michigan?
Yes.
Were you able to make contact with anybody involved in that accident?
Yes.
Who?
Sierra Robbins, the driver.
And do you see Sierra Robbins here in the courtroom?
I do.
Can you point her out and describe something she's wearing?
She is in the black knitted sweater.
Your Honor, I request that the record reflect that this witness has identified the defendant.
Any objection?
No objection from the defense, Your Honor.
ID is noted.
Thank you, Your Honor. Now, when you made contact with Ms. Robbins, what was she doing?
She was in the back of the ambulance at that point.
And did you have an opportunity to speak with her?
I did.
What was that conversation?
I can talk to her about her bloody nose for a little bit, got her license, and then we did talk about insurance.
And what happened when you started talking about insurance?
To my recollection, I began asking where it was at. She told me the glove box. To my, again, recollection, I said, do you mind? She was interrupted. She said, go ahead. I went into the glove box, and at that point, I found a firearm.
And do you remember what kind of firearm that was?
It was a revolver.
Do you recall if Ms. Robbins had a CPL?
She stated she did, and she did not.
Okay, can you describe that a little bit?
So I asked her, I said, hey, what's up with the firearm in the car? She said, oh, I have my CPL. Tried to confirm that she did not. And then she said, well, I carry under the certificate of completion, which is not by law a CPL.
Okay. And were you able to run a law enforcement check on her?
Yes.
Did it come back as her having a CPL?
She did not, no. I had Ingham County lead run that.
Okay. And did she acknowledge that the gun was in fact hers?
She said that her dad bought it for her under her dad's name.
But she knew that it was in the car, is that correct?
Yes.
Okay. I have nothing further at this time.
Cross-exam.
Indictment for felony manslaughter. Even so, under Texas Penal Code Section 201, the state remained responsible for proving every element of the offense beyond a reasonable doubt throughout the trial. During cross-examination, defense attorney Marissa Jovenko challenged Sergeant Morales' investigation by focusing on what she described as a critical omission in his supplemental report. Relying on Texas Rule of Evidence 613, she questioned why information concerning Mr. Fernandez's alleged speed and intoxication had not been documented. Sergeant Morales agreed that the purpose of a supplemental report is to preserve all material investigative findings. The defense argued that his report failed to meet that standard because it omitted information they believed was significant to the case. Jovenko also highlighted the requirements of the Texas Department of Transportation CR 3 crash report, which is intended to document the contributing factors of a collision as part of the official investigative record. According to the defense, Sergeant Morales left the—
Good afternoon, Officer Burkett. Did you do any type of work to prepare for this hearing today as far as reviewing materials?
I tried to, however, this was a last minute subpoena, so
Okay. So,
called in day of.
did you have a chance to review your your police report?
The report, yes, Bodycam, no.
Okay, so not the body. So did you, and you recognize that this is the report that you wrote back on December the 12th?
Yep.
And when you do a police report, do you essentially kind of go off memory, or do you go by like the notes you take on scene, or how do you do that?
All of the above.
Okay. And do you remember specifically in this case, did you use all of the above?
Yep, I used my memory and the notes on scene. This report was written shortly after the accident was.
And Officer Burkett, when you were arriving on scene, did you turn your body cam video on that day?
I was running code there, and so with the way our cars are set up, it automatically turns our body camera on while we're running.
Okay, so your body cam was clearly running throughout this entire situation?
Yes.
Your Honor, at this time, I would like to show Officer Burkett a portion of her body cam video. I'm currently on Zoom to accomplish that.
Just for clarification, are we admitting this as an exhibit or for impeachment?
For impeachment.
Okay, understood. Thank you.
And let me also just state that. So it is your testimony today that essentially Ms. Robbins gave you consent to search her glove box prior to you going into her car?
Yes, in the way I perceived it, yes.
Okay.
Around.
Okay, so I'm starting at about 1 minute and 40 seconds into this video. Does this appear when you arrive on scene?
Yes.
And is that, looks like the fire department's already there to assist the driver of the vehicle?
Yep.
And you were not called to the scene as part of like a criminal investigation?
No, no
right?
criminal investigation, no.
This is just an accident, somebody hit some ice or something like that, is it your report?
Yeah.
Go around. I don't think this is the one. Was there another vehicle involved in this?
No, she says she hit the ice back here, and obviously you can see she definitely came up through.
Is this her?
This is her here.
25 good place. Edward Tom Queen 98457 Ethan Oxford, hopefully.
Sounds like she's
Officer, is it, after seeing this video, is it clear that you actually had contact with Ms. Robbins prior to her being in the ambulance on this occasion?
Yes.
on the car. Witness said she spun out, hit that pole.
I came like from back there. Why don't you get in our ambulance? I can check you out and I'll come to you in a second.
Okay. With you having seen now your first contact with Ms. Robbins, did she attempt to essentially tell you about the scene, about what happened with the car?
Yes, but I prioritized her injuries rather than a statement at that time.
Okay, so you sent her away to the ambulance.
Yes.
And so there's been no consent to search the vehicle at that point, having what you've seen there? An officer, is that you opening the car door, opening the glove box, and starting to pull materials out of the glove box?
Yes.
See if it was in park.
I'm sorry, what?
I was just seeing if it was in park.
Okay, and then officer, is that you proceeding to essentially kind of search through the center console of the vehicle at that time?
Yes, but not for any criminal reasons.
Section addressing contributing factors blank rather than documenting Mr. Fernandez's alleged speed or intoxication. The defense argued that this omission weakened the reliability of the state's investigation and raised questions about the completeness of the official record. After hearing all of the evidence and arguments presented by both sides, the jury returned its verdict on April 17, finding Simon Alexander Garza not guilty of the manslaughter charge. Following the jury's acquittal of Simon Alexander Garza on the manslaughter charge, attention shifted to a separate criminal case from Lansing, Michigan. On January 5, 2025, Sierra Ryan Robbins was arraigned in the 54A District Court on a felony charge of carrying.
You searched the console, you said?
Yes, I only search the places that are people most commonly hold their insurances.
Okay.
Okay.
Okay, and that would be the moment that you found the firearm in the glove compartment?
Yes.
So after, I guess, seeing this video, is it now your testimony that you did not speak with Ms. Robbins at the ambulance prior to going into that car?
Correct. After seeing this video, it is refreshed, yes.
And it is also your testimony that you had no probable cause of a crime being committed on scene?
Objection, Your Honor, that is a legal conclusion.
Your Honor, I'm asking what her reasoning to search the vehicle.
No, she can make a determination as to whether or not there was probable cause to search.
It is our policy and procedure that whenever there's an accident, we get license, registration, proof of insurance. At this time,
The question is whether or not you have probable cause to search.
no.
And based on the video you've seen now, you did not receive any consent from the driver to search those areas of her vehicle, is that correct? And this video was a fair and accurate representation of what went on?
Yes, this is what happened.
Can you just replay it, because I think maybe I missed something, unless can you replay it?
Sure.
The portion that you originally played.
Carrying a concealed weapon in violation of Michigan Compiled Laws 750-227. The charge stemmed from a December 12, 2024, single-vehicle accident at the intersection of South Pennsylvania Avenue and Alden Drive. According to prosecutors, Ms. Robbins was in possession of a firearm that was unlawfully concealed inside her vehicle. After Officer Elena Burkett of the Lansing Police Department responded to the crash scene, she conducted a search of the vehicle and discovered the firearm. The defense, however, argued that the search violated Ms. Robbins' constitutional rights and that any evidence recovered as a result should be excluded. Ms. Robbins entered a plea of not guilty, and the court scheduled a preliminary examination to determine whether sufficient probable cause existed to allow the felony charge to proceed to trial. The hearing took place before Judge Kristen Simmons in the 54A District Court. The prosecution was led by Assistant Prosecutor Abigail Wilson, while Attorney Luke Goodrich of the Ingham County Public Defender.
Are you aware of any requirements that individuals carry insurance when they're operating a vehicle?
Yes, it's law.
Okay. And you said, I believe on cross, that it's routine for your department to ask for that insurance. Is that correct?
Yes.
And was that your purpose in going into the car, was to confirm that there was in fact insurance?
Yes.
Okay, thank you.
My purpose was if she's being evaluated for an injury, there's a chance this vehicle is going to be towed.
Well, strike that. There's no question. You know, but I have a question now.
Yes.
Because maybe I missed something. You testified on your direct that she gave you permission to go in the glove box. She told you that the insurance was there.
Yes, this was prior to being refreshing.
Okay, so the video we show is accurate that she never told you that she had insurance in the glove box.
Correct.
And so you went and opened the door without her permission.
Correct.
And went in the glove box.
Okay.
And then went in the center console.
Correct.
No permission.
Correct.
No probable cause to search.
Correct.
Okay. Well, why are we still here?
If I could have a moment, Your Honor.
Thank you.
Thank you, Your Honor. Based on the testimony here today and the evidence, we are at this point not requesting bind over on this charge. Thank you.
Case is dismissed. You're all set. We'll get you a dismissal.
Thank you so much.
Prosecutor's office represented Ms. Robbins. As the hearing began, Officer Elena Burkett took the witness stand and testified about her response to the crash, the events that followed, and the circumstances surrounding the discovery of the firearm inside Ms. Robbins' vehicle. Ability of defense counsel to carefully examine every piece of evidence presented in court. In both trials, defense attorneys scrutinized the investigating officer's actions, pointing to alleged procedural errors, incomplete documentation, and inconsistencies between courtroom testimony and the objective evidence. In Garza's case, the defense questioned Sergeant Richard Morales' investigation, arguing that important evidence was either overlooked or omitted from the official reports. In Robbins' case, the defense relied heavily on body camera footage to challenge Officer Elena Burkett's account of obtaining consent to search the vehicle, ultimately persuading the court that the search lacked a lawful constitutional basis. Although the facts and legal issues differed, both proceedings underscored the same principle: criminal convictions.